Brussels to the Bay. This must be like 30th version or edition of Brussels to the Bay. It's a bit of a different one, not only because like we're doing it late in the afternoon. Typically we do it early in the mornings also, then we connect with Brussels. So this is different. The other thing is different. We have the honor of the presence of the Commissioner McGrath, Commissioner for Justice, Democracy, Rule of Law, and Consumer Protection. So that's different. It's really a pleasure to have you here. What's also different is then typically we would have a panel where we have Commissioner McGrath, who's like, he will be kind of very, very interesting. So we don't need a panel actually tonight. And then we have one moderator, like Fireside chat version of the Brussels to the Bay. So welcome to people who are here physically. Also, I have to stand here. I can't move because we have also people joining us virtually. So welcome to those people who are joining us virtually. Commissioner McGrath has been commissioner since December 24, so almost a year and a half now. This is not his first visit to San Francisco, actually not even his first visit here, because of course you will all know this is also the Irish Consulate General, so it's like tonight it's Europe House, but it's also Ireland House. Commissioner McGrath came here in 2022, and then he came back in early 2024 as the Minister of Finance, but today, I mean, he's visiting, and I mean, actually arrived yesterday. Had some really interesting meetings already yesterday, even though the plane was slightly late. We all made all of the meetings, and then today was a full day here in San Francisco. Tomorrow it's Silicon Valley, but the Commissioner is here, of course, in his capacity as European Commissioner and not as Minister of Finance for Ireland. I'd like to welcome also the moderator, Jim Dempsey, and I just asked him, because Dempsey is, of course, a very Irish name, so does he have any Irish roots? And the answer is yes, I have Irish roots, but not through my father, but through my mother. So I was a little bit like wrong-footed by the Dempsey name, so it's different roots. Very much looking forward. There's lots to discuss. I mean, the portfolio of the Commissioner, I mean, think about it, justice, democracy, rule of law. I mean, rule of law, I mean, it's quite relevant nowadays, and of course, consumer protection. So a very, very wide area of responsibility. So there's much to discuss also in context of the transatlantic relationship. So I'm going to hand over to Jim, ask the Commissioner to take the stage, and looking forward to a really lively discussion. Of course, first, Jim will take it away, but then there'll be an opportunity for Q&As as well. Be around like 45 minutes. Yeah. Okay.
Jim.
Gerard, thanks for those remarks, and thanks to you and your team for all the work you do here in San Francisco, building bridges with the EU, with Silicon Valley, and with the broader U.S. tech sector. I feel slightly responsible to the people in the back of the room. I said to the staff of the EU earlier this week, you know, there's always a large drop-off in terms of attendance at events that are free. So let the event be oversubscribed, otherwise there won't be empty chairs. And it turns out we have 20 or almost 30 people standing in the back. Hopefully we'll make it worth the stand, and you are closer to the wine. So governments around the world are obviously grappling with the same set of issues. How to promote innovation and the fusion of digital technologies in ways that support economic growth, human development, child safety, consumer protection, and the integrity of our democratic processes. The head-spinning developments in artificial intelligence only make that task more difficult and more urgent. In many ways, the US and the EU share a common set of values: commitment to free and competitive markets, commitment to scientific research and technological innovation, and to human rights. However, the legal frameworks of the US and the EU with respect to digital innovation and markets are remarkably different, to the point sometimes almost of mutual incomprehensibility. This evening, we have a unique opportunity to build some understanding of the European approach and where it is going. I assume most people in this room, most online, are familiar, but just before diving in, it may be useful just to have a recap of some of the major institutions of the EU. There's the Court of Justice of the European Union, which interprets laws and resolves disputes, both commercial and related to human rights. The European Parliament, 705 members directly elected by the EU citizens, which approves or rejects legislation. The Council of the European Union, not to be confused with the Council of Europe, the Council of the European Union, comprised of the ministers of the 27 member states, which shares with the Parliament in adopting a legislation. And there is the European Commission, which develops, drafts, and proposes legislation and works to achieve its enactment, working with the Parliament and the Council, and oversees its implementation. The Commission is divided into 27 departments called Directorate Generals, Directorates General, or DGs, and served by a staff of 32,000 public servants with deep, deep expertise and long commitment to the European project. Which brings us to our distinguished guest, Michael McGrath, who, as Gerard said, is Commissioner of the Directorate General for Justice and Consumers. Specifically, he is responsible for democracy, justice, the rule of law, and consumer protection, which includes a wide range of issues, including election integrity, consumer protection, as the name indicates, data protection, or as we say in the United States, privacy, and international data flows. Commissioner McGrath has a distinguished career in public service, starting as a member at the very lowest level. I guess you weren't on school board, but you were on the local city council in his hometown in Ireland, then serving on the Cork County Council, then serving for 17 years in the Irish Parliament, then as Ireland's Minister for Public Expenditure and Reform, then as Minister for Finance, and as Gerard said, becoming EU Commissioner in 2004. So Commissioner McGrath, delighted to meet you. Thanks for coming to San Francisco. I know you've had a busy schedule already.
Yeah, likewise. Thank you so much, Jim. It's a real pleasure to be here this evening. Can I thank Gerard and his whole team in the EU office for working so hard over a number of months alongside my team in the cabinet led by Fiona Canablunny, my chief of staff, as we call her when she's in America, on putting together such a fantastic program. And thanks to Micheál Smith, Ireland's Consul General, for generously providing the space here this evening. And what a spectacular setting it is. So if my eyes kind of glaze out the window, it's just to get a glimpse of the bay every now and then. That may well happen. But as you say, it is my third occasion here, and it's a wonderful honor, and to be back here in a different capacity, but bringing the experience and the perspective that I gained through the 25 years in Irish politics. I think it does enhance the role that I have now, and that experience is very valuable.
So we want to cover in particular 4 topics this evening that you're involved in. EU Inc., data protection, proposed or forthcoming Digital Fairness Act, and the Democracy Shield Initiative. We're going to have time at the end for questions. We're going to go the full hour. We started a little late. We're going to go the full hour. And at the end, I'm going to welcome questions from the audience and also from folks who are online. So diving in, EU Inc., what is it? What are its goals? What is the path to realization?
Okay, thank you, Jim. So it's one of the flagship initiatives that the European Commission has brought forward in an effort to make the European economy more competitive and to address the fragmentation that we have across the single market. We have a fantastic single market, 27 countries, 450 million people, but it's not a complete single market in many areas. So at the moment, we have 27 different national legal company systems. And within that, actually, we have a total of over 60 different forms of companies in the European Union. And what we hear all the time from people who want to establish a business and those who have established a business but want it to scale and to grow in the European Union is that one of the issues that holds them back is the fragmentation, having to navigate all of those different national systems. So what we are proposing is not to take anything away from any individual member state, but to add an option. So an optional additional regime that we now call EU Inc. It was known as a 28th regime that has now come to represent a broader concept, which I can come back to. But EU Inc. represents a new set of harmonized EU corporate law rules. So it'll be the one set of corporate law rules for a company in the European Union. Exactly. Yeah.
Registration.
With a few key principles and characteristics. It will be digital by default. And some member states already would say, well, you can set up a company in an hour or two in our member state, but that's not the case everywhere in the European Union. So digital by default, right the way through the life cycle of the company, from birth to growth, and even if it ends with failure, digitalized insolvency as well. A company that can be set up within 24 hours or 48 hours at minimum cost of no more than €100, for example, and that would have no minimum share capital requirements, and that would be streamlined, flexible, simple, all the way through the life cycle of the company. So yes, including formation, including issues around share issuance, capital formation, fully digital procedures, including online meetings, for example, of shareholders, and a simplified insolvency regime as well. And we're proposing that there would be a standardized EU employee stock option plan with a harmonized timing of the taxation liability, which again is an issue that that business owners raise with us regularly, that as they try to attract and retain talent in the EU, we know that stock options is a key instrument, but again, they have to navigate many different national systems. So this is a single corporate law rulebook for a company that will have the term EU Inc. At the end of its name, and which will be seamlessly recognized throughout the European Union.
And is the theory this would be a regulation which would become binding on member states, or how would that work? I mean, would this be, it would or would not require transposition into the laws of member states?
Yeah, correct. So the instrument of choice on this occasion is a regulation, because of the very motivation to get away from fragmentation. Were you to go down the road of a directive, it would have to be transposed into national law. The manner of transposition could vary. There could be add-ons and there might be differences, and you could end up with 27 versions of this new EU Inc. or 28th regime, which would defeat the whole purpose. So it will be a direct effect regulation under Article 114 of the treaties, and we hope to have agreement between the European Parliament and the Council by the end of this year, and then hopefully a relatively short lead-in period and application as soon as possible. It will build on many of the reforms that have been adopted of EU company law in recent years, where a lot of progress has been made, and that should be acknowledged. And there will be a new EU corporate ID. There will be a business wallet. There is already a business.
Again, this business, just a couple of sentences on the business wallet. What is the concept of the wallet?
Essentially containing all of the essential company documents and information that is needed. The new EU Inc. Company form will be characterized by this once only principle, because again, one of the complaints we hear is that I keep have to giving the same information to different bodies and at different points of the life cycle of the company. We want to get rid of all of that. So you give the information once, and then that is shared with the tax authorities, the social security authorities, to make the process as simple and straightforward and digital as possible. So those are some of the main elements of it. And now we have to have a negotiation, which we will guide and support. Ultimately, the co-legislators have to make the decision, but we will be strongly advocating that they maintain the integrity and the simplicity of this proposal. Simplicity is key, and we have to make sure that the final product is one that is attractive to investors, because we know that capital is the oxygen that businesses need, especially as they grow and scale. And in Europe, we have a real difficulty in that we don't have the same depth of capital markets, so we need to reform all of that. But these companies, through the simplified capital processes, should be much more attractive to receive investment. I would make one additional point, if I may, Jim, and it is that EU Inc. has great potential, but for it to reach maximum potential, it has to be accompanied by all of the other reforms to address the incomplete nature of the single market. Because while EU Inc. addresses, so EU Inc. addresses the company law fragmentation, that will be fully resolved, but we don't have a complete single market in the area of financial services. So an EU Inc. company goes about setting up a bank account, then it still has to navigate the complexity that is currently there. So the Savings and Investments Union, the Banking Union, critically important that we move ahead with all of these reforms to deepen the integration of the EU single market and essentially complete it to a much more advanced stage than it currently is in energy, in telecoms, in financial services, and we could go on. And that all of that is key, and that must travel in parallel with the EU Inc. proposal for it to have the maximum effect.
And banking has long been one of the pain points for companies of all sizes, but particularly
It has, and we have ambitious plans. You might say that we have long had ambitious plans, but they haven't come to fruition. But under the leadership of Commissioner Albuquerque, and with the political will now there, and I believe it is, and I'm not understating the level of difficulty that there will be with some of these reforms, because in certain cases we are asking member states to give up something, and if we want to have much deeper capital markets, more integrated capital markets within the European Union, then member states will have to play their part in helping us to achieve that. But that's an essential ingredient in making Europe a more attractive place for businesses to grow. We don't have a problem with innovation. We don't have a problem with the number of entrepreneurs, or indeed with the skill set. The number of people with degrees, postgraduate degrees, PhDs in Europe is really high, compares favorably with anywhere else in the world. But where we have the problem is in scaling and in dealing with the fragmentation of the European single market and in attracting capital. And we need to improve the infrastructure to enable that capital to be deployed in Europe.
And this is informed by the overall theme of a certain fear, and we'll return to this later when we talk about privacy, but there's certain fear, I think, or concern that Europe has been outpaced by the US, outpaced by China, other countries in innovation, business development, startups, entrepreneurship. Is that fair?
Yeah, the innovation is starting in Europe, but it doesn't stick in the same volume or at the same depth as it should be. So we don't have a problem with the number of companies being founded. We have many successful companies in Europe, but we just don't have enough examples across the different sectors of companies that begin in Europe and reach a truly global scale with Europe as their base. And that is fundamentally the issue that we are seeking to address. But of course, global markets are completely integrated, and we have to recognize that companies may need to go to different parts of the world for different elements of what allows them to grow. But we want their fundamental base to be European, and we believe that these are the critical building blocks that will allow that to happen.
EU Inc. would be voluntary, right? The company could choose it. It's not, you don't
Correct.
have to go that route.
Yeah.
And would it be open to all companies, or just companies of a certain size? Is it targeted at startups, or?
So it will be open to all companies. We anticipate all private limited companies. We anticipate that the vast majority of EU Inc. companies will be newly founded, established companies, but there will be the option to convert an existing company into the EU Inc. Company form. And we think that within the next decade, we will see considerable growth of EU Inc. companies in the European Union if we get this right. And I think there's a window of opportunity now that we must seize. I think the political will is there, and we have had fantastic support from the ecosystem, from the startup and scale-up community within the European Union. There are areas where they'd like us to do more, but I think they recognize that there are limitations, and we have to bring all of the stakeholders with us. And ultimately, we had to bring forward a proposal that stood a more than realistic chance of actually getting agreed. And I believe that this will, because we've tried this before, remember, there have been a number of attempts to bring in a new EU-wide form of company, but not successfully. And we've looked back at why that didn't happen successfully, and why even in the case of the SE company form, its potential was never fully realized. It was because of, in my view, design flaws at the very beginning, that there was too much discretion at a member state level. You had high barriers to entry, very high levels of minimum share capital, for example, and you couldn't establish one from scratch. So these were real issues that we had to address. And I think we've come up with a very good proposal, and we hope now it will meet with support, and I believe it will, and I believe this will happen. But it does need to be accompanied by all of the other reforms if we are to really sweat the asset.
We may come back to EU Inc., some other questions, but let's shift to privacy or data protection. Obviously, the General Data Protection Regulation, the GDPR, has been very important in the United States, important around the world. Every company in the world that does business in the EU and collects data there on EU residents has had to become GDPR compliant. And it's been a model for privacy laws in countries around the world. It's been a model actually for what we are now calling the comprehensive state privacy laws in the United States. They may not have all of the protections, but for example, the controller processor terminology of the GDPR now is showing up in all of the state laws. I think we have 20, depending on how you count, 21 of them. Oklahoma just was adopted a couple weeks ago. So that has had huge impact, but at the same time, within Europe, it's generated a certain concern. Again, this question that I see, at least what I pick up, is this concern about, are we actually facilitating the digital economy? And of course, in 2025, former Italian Prime Minister Mario Draghi issued a report talking about the negative impact of the EU regulatory structure on innovation, and suggesting that Europe had lost out or had lost its mojo on innovation because of this overly complicated, overly prescriptive regulatory structure, including on privacy. Where do you come down on that, specifically with respect to privacy and the GDPR and the overall data protection scheme in Europe? How would you assess? And then secondly, I'm going to go, where do you see as the path forward? But first of all, just what is your overall view on, pluses and minuses of the GDPR as it's been implemented so far?
I think many more pluses than minuses. I think in many ways it has become the global standard. And we are proud in the European Union that we do afford a high level protection to personal data. It is part of our value set. It is part of the Charter of Fundamental Rights. It is in our treaties. It has been interpreted by the Court of Justice of the European Union. And we will continue with that high standard of personal data protection. That said, the GDPR is approaching a decade old, and we don't need to rehearse or rehash what has happened in the last decade and the pace of technological development. And so I think it is timely that we have a look at it, and we have done that, and we have come forward with some targeted amendments which we can come on to discuss if you wish. But I think you're right in saying that it is recognized globally as being a very high standard. We have now entered into 18 different adequacy decisions whereby we recognize that the personal data protection standards of other jurisdictions are comparable to ours in the European Union, and therefore that gives us the confidence to allow for a free flow of data, and many countries have recognized the European Union as being at least comparable to their own standards. And for example, here in the US, we have an EU-US data privacy framework, which underpins about €1 trillion of transatlantic trade every year. And 3,500 US companies have signed up to that data privacy framework, including many companies here based in California. And that framework is based on certain foundational safeguards, which we have emphasized in our contacts with the US administration, that those safeguards must be maintained in order for everyone in the EU to have the confidence that the personal data of EU citizens, when it is transferred here, is treated in the same way and to the same standard as it would be in the European Union. And so we are committed to that data privacy framework. We think it's critically important for our respective economies and facilitates massive investment flows two ways and helps to support millions of jobs in the US and in the European Union. We also have new adequacy decisions, including with Brazil, where I was in recent months, and we are negotiating with a number of other countries who want to have an adequacy decision from the European Union, because we know it is in many ways the gold standard that recognizes their high standards of data protection.
And most people here are probably aware that in terms of the transatlantic data flows, EU-US, you referred to the DPF or Data Privacy Framework, which is an agreement between the EU and the US in which American companies wishing to import data from Europe into the US agree to a certain set of protections, which are equivalent to the GDPR protections. And the US government agreed to certain steps and measures intended in terms of its intelligence and national security and law enforcement access to that data to respect the privacy rights of Europeans. This is attempt number 3. We had the Privacy Shield. We had the Safe Harbor, that failed. Was rejected by the CJEU. We had the Privacy Shield. That was rejected by the CJEU. Now we're on to step number 3, the Data Privacy Framework. Different outcome, and why?
I think it will endure because it is mutually beneficial and it is based on the mutual upholding of standards. And I believe there is that recognition in the US. Certainly there is on the European Union side, and there is too much at stake to allow it to slip. And so we continue to engage with our counterparts in the US administration. We know that many large US companies who are direct beneficiaries of the DPF are on the same page as us in that respect. But it is predicated on those foundational safeguards being maintained, including the executive order that underpins it. And we continue to monitor developments. There has been a court challenge, as you know, in the European Union. We face questions from time to time from members of the European Parliament when they hear certain policy statements and announcements across the Atlantic. And so, of course, we keep an eye on it, but it's critically important, and I do believe that it will endure.
Let's go back to the GDPR itself for a second. And a lot of EU's current goals around simplifications of its digital regulatory regime are reflected right now in what is called the Digital Omnibus, which is a package of reforms intended to provide immediate relief to some of this fragmentation and some of the lack of clarity and other issues. The emphasis now is on pragmatism, business friendliness. Among the changes proposed in that package put forth by the Commission is some clarifications to the definition of personal data in the directive. And these clarifications are in some respect actually intended to codify decisions of the CJEU on what is the standard for re-identified or de-identified or anonymized or pseudonymized data. Just briefly, what is the proposed change? How far-reaching is it? What is your response to some of the criticism that I've seen that this would gut the GDPR?
Yeah, I think the amendments that we have brought forward are quite targeted and are proportionate. As I said, we are almost a decade on from the GDPR coming into application, and so much has happened in that time, not least the pace of technological development, the development of AI that we may well come on to discuss. And last summer, I held an implementation dialogue, which is where we basically get all of the key stakeholders around the table. We asked them their views on the application of the GDPR. And in the main, they wanted the GDPR to be maintained with some targeted changes. The key issue actually that came up time and again in that engagement and others was the need for consistent application of the GDPR throughout the European Union, because as you know, it's not adjudicated upon by one EU body. It's adjudicated by the 27 different national data protection authorities. But there is a level of coordination through the European Data Protection Board that brings together those national DPAs. So we are working hard to ensure a greater level of consistency, because again, what you hear from businesses is, when it comes to data protection, can we have one rule book, please, for the European Union, which we know will be interpreted the same way in every member state of the EU. The amendments that we have brought forward are based on opinions that have been issued by the European Data Protection Board and indeed on judgments that have been issued by the Court of Justice, which we believe should be codified in the interest of clarity and providing certainty to data subjects and to data controllers and indeed others. So without getting into the granular detail, we are clarifying the notion of personal data, for example, concerning pseudonymized data, that in the hands of a data controller, where it's not possible for the identity of that person to be identified, and that it can be essentially used. Yeah, and
fall outside of the definition.
Fall outside of the personal, yeah, the definition of personal data. And then when it comes to the use of personal data for development and training of AI, we are also providing more clarity in that area too. So there are a number of quite limited targeted amendments. There have been criticisms. We take note of those criticisms. Those will be considered by the co-legislators. We will support the process of negotiation. We will provide our analysis, which we think is solid and is based on the evidence. But as is always the case, we are there to support the members of the European Parliament and the member states in the institutional negotiations that will now take place on this issue.
And anything else that you would call out from that digital omnibus package that you think is particularly important?
Well, we have proposed certain amendments to AI and AI Act, and to the Data Act. There are some changes in the timeline of the AI Act that my colleague, Executive Vice President Henry Verkunnen, has brought forward, and also in the area of cyber. So it's quite a comprehensive and complex piece of legislation. I would encourage everybody with an interest in those different areas to examine it. And it will be a negotiation that will require a lot of investment by the European Parliament and by the member states. But the indications are that they want early agreement and intend to move ahead now quite quickly.
And I worked on Capitol Hill for 10 years, and there's always this question of, do you try to put everything into one big beautiful bill and get it all passed at once, or do you work incrementally and take little pieces? As I understand it, that the digital omnibus, one piece of legislation that would amend multiple existing instruments, is it possible that it would be broken up, or are you continuing to push for the one big beautiful omnibus?
Yeah, so we have brought forward 10 such omnibuses at this stage, and Yeah, it is a legislative vehicle that in itself amends a number of constituent legislative instruments, and some of them are in the form of a package of measures. So it is complicated, but yes, in principle, it is a piece of legislation that amends a number of existing pieces of legislation. And that's what the Digital Omnibus seeks to do through the amendments to GDPR, to the AI Act, to the Data Act, and so on.
Let's shift now over to the Digital Fairness Act. So at the same time that you are looking with the omnibus to streamline, consolidate, simplify, clarify, you're also developing the Digital Fairness Act aimed at consumer protection, aimed at digital services. Basically, what is in that, or what will be in that, or what is being considered for inclusion in that? As I understand, there's not a proposal yet, but it's under consultation and it's internal to the commission now. Where do you want to see that go? What do you think should be addressed in that?
So the aim of the Digital Fairness Act will be to address any remaining gaps in the area of consumer protection in the online environment. Fundamentally, that is the objective of it. It is not to reopen or revisit matters that have already been regulated or already settled. So it is where we have clear evidence based on the digital fitness check that we did, based on the public consultation, that there are gaps in the law. So we have said that it will examine issues such as dark patterns, addictive design, unfair personalization, the role of social media influencers, the difficulty consumers can have in cancelling subscriptions that they may have entered into, and we will be placing in particular focus on the protection of children online. So to take, for example, the main digital instrument that we have of regulation at the moment is the Digital Services Act, but you only have a certain number of platforms that are within its scope, and it addresses only to a very limited extent consumer protection issues. So in the main, consumer protection issues in the EU are dealt with by the horizontal body of consumer protection laws that we have, mainly in the form of EU directives that have been transposed into national law. And then national laws can add to that or can sit alongside that. At the moment, consumer protection is enforced generally by the national consumer protection authorities. We do play a coordination role, but we do see clear gaps. For example, when it comes to children, so the DSA does prohibit the use of profiling children as a basis for targeted advertising, but that only applies to the platforms that are within its scope. It doesn't apply to all.
And what's an example of one that's not currently in scope that you would want to bring in? Can you give?
So that only applies, that example only applies to the platforms that are within the scope of the DSA. It doesn't apply to all of the other online platforms, online retailers who may be doing the same thing, who may be targeting and profiling. Very large. Yeah, exactly. Yeah.
This would cover a wider range of entities.
Yeah, with a broader reach of e-commerce, online retailers, marketplaces, and so on.
And it's interesting because a lot of these issues right now are being addressed in the United States. There's a number of cases pending around, particularly the addictive aspects of social media. And talk about fragmentation, we're going to have multiple different court decisions singling out different types of features that may or may not be ruled to be addictive, or for which the companies may or may not be held liable. You're going to want to try to set obviously an EU-wide rule, but how will you define those features of a platform? And take a TikTok, an Instagram, a Meta, Facebook. What will and the features have come up in some of these cases domestically in the United States, where parents of children who have either died or committed suicide, or individuals who have suffered what they call addiction, have singled out, oh, how will you do?
Yeah, well, that's exactly the challenge, because we might all have a general idea what these concepts mean, but writing legal text and writing law is an altogether different challenge. And that is what we have to do. And it has to be very carefully constructed. But one of the reasons why it's necessary is that we hear back from the consumer protection authorities around the EU that on certain issues, they feel the law isn't clear enough, that they feel something is wrong and should be tackled, but they don't have the confidence to bring a case. So it is about clarifying law, addressing any remaining gaps. We know it is coming at a time when, in many respects, the trend is in the other direction. It is towards simplification and easing the burden of regulation. But actually, if you think about it, the Digital Fairness Act will address fragmentation, because in the absence of us doing this centrally as a commission and bringing it about in all of the EU, we see more and more national initiatives, which is the very thing that businesses don't want to see happen, because then you have the patchwork quilt of regulation on issues that are EU-wide and should be dealt with on an EU-wide basis. And we also have made the point and given the reassurance that this will be a vehicle that also will, in many ways, be pro-business, will involve simplification elements and simplification initiatives. We have invited businesses to make proposals to us, and they have made many, including, subscription-based streaming services would make the case that the existing right of withdrawal is stacked against them, for example. And we've heard that point, and we are examining it for potential inclusion in the Digital Fairness Act. So we know that we have to get this balance right. It has to address gaps, make sure the law is absolutely clear and can be consistently applied in the EU. But we do have real evidence of consumer harm and consumer detriment amounting to many billions of euro every year arising from these issues. And that will be the basis on which we develop this proposal.
You've probably heard it in the United States. We refer to the states as the laboratories of democracy, by which we say that, the 50 states can experiment with different approaches. They can adopt different laws. They can test things out. Some things will work, some things won't. There is an advantage to having 27 member states acting as the laboratories of democracy, or the laboratories of enforcement. So even if you adopt, for example, something that clarifies the authority of the member state regulatory bodies to address dark patterns, to address addictive design features, to address unfair personalization, the different member states will come up still with different implementations of that, won't they?
Yeah,
and that might not be bad.
But I think the first hurdle you have to clear is having clear law. If you have the combination of unclear law and differences in implementation and application, then that's a recipe for a very unstable environment. So our role as the guardian of the treaties and as the executive body of the European Union is to propose clear law that we believe stands the best chance of being implemented in the European Union. You cannot discount the possibility of different interpretations. We know that happens all the time in jurisdictions all over the world where the same law is looked at and different judgments are arrived at. But that's the challenge of legislators, is to make sure that the law is as clear as possible and that it's supported then by clear guidance that does deal with different scenarios, and that you remove that element of, well, it could be this or it could be that. And if you are a consumer protection authority and you receive a complaint from a consumer who thinks they've suffered detriment for a particular reason, and if they're looking at law that is not clear, then they may not take the action, or they may take it and they may lose.
But then you'll have that process, and then you may, 10 years down the road, need to have another omnibus clarifying and stabilizing the law. But I think until you're saying until you give the national authorities the power to even address these issues, you're never going to even get close to clarity.
Yeah, and look, nothing is static on these issues. I mean, the nature of consumption and consumer decisions and commercialization is changing all the time with technology. But we have to lay out very clearly what the principles are. And it is a challenge to write that in legal text. But if you don't, the alternative is that consumers continue to be harmed and companies continue to have a lack of clarity about how certain issues will be adjudicated upon within the European Union. And we're a big market, 450 million people, hugely attractive to American companies who do very well in the European Union, and they're very welcome in the European Union. They deserve to have clear laws, and the consumers deserve to have laws that protect them at the same time.
When could we expect to see a draft of the
by the end of the year?
Turning to our last issue, and then going to go to audience and online questions. The European Democracy Shield, another one of initiatives that you've been deeply involved in. What is the European Democracy Shield, and what prompted it?
Well, I think that's a good place to start. What prompted it is a recognition that democracy is fragile, that it is precious, and we should never take it for granted. I sit around the Commission table every week at our meetings with colleagues who have grown up in societies that were not democratic, who only got their democracies, 35 years ago. And they would highlight to us, as they often do, what that experience was like. So democracy is actually quite recent in parts of the European Union. And it needs to be nurtured, it needs to be protected, and it needs to be invested in. And we know that with the development of technology, there are enormous benefits, the ability to spread information and to have facts amplified and shared, allowing people access to information to make up their mind when it comes to elections. But it can also be a source that is manipulated, and it can be a source where misinformation and disinformation is spread. We know the extraordinary power of technology and of algorithms to decide what content we see. We know what the role of AI can provide in the context of elections, with the generation of deep fakes in the hours and days leading up to people going to the polls. And we know that there are actors, not least Russia, that would seek to undermine democracy in the European Union because they do not want to see a strong European Union. They would love to see the breakup of the European Union. And we have the clear evidence, it's there for anyone to see, of interference in elections within the countries that want to join the European Union. I was in Moldova recently and heard the direct reports of the extraordinary level of interference in their parliamentary elections last year. And there has been interference in Europe too, because the aim is to sow mistrust, is to undermine public confidence in public institutions in the European Union, and to undermine democracy itself. So we shouldn't be naive in thinking that there are no risks. And so we felt that there was a need to invest in democracy, to support it, and I'm happy to go through the different elements, but fundamentally...
What would you single out? Yeah,
well, fundamentally, it's about supporting the citizen, first of all, making sure that they have the skills and the information and access to the information that they need to make up their mind. All that we want is for every individual citizen in the European Union to continue to have the privilege of participating in free and fair elections and the right to decide for themselves who should represent them locally, nationally, and at European level. And we know the destructive effect that concerted disinformation campaigns can have, harnessing the power of technology to impact on our elections in the European Union. This is a threat that nobody is immune from, and we have to respond to that in a way that is measured, because we have to, at all costs, protect freedom of expression. which in the European Union is a fundamental right of every citizen of the EU. It's part of our Charter of Fundamental Rights, and it's in our it's one that I, as Commissioner, actually have a role in ensuring is protected. So these allegations of censorship and so on are just not borne out by the facts.
Let's hit that head on, because when I read some of the materials around this, it talks about the creation of a new European Center for Democratic Resilience to bring together EU and member states' expertise and resources. It talks about the creation of a stakeholder platform will be established within the center to facilitate dialogue with trusted stakeholders, civil society, and media providers. And I think that's partly what critics of this or people have used to talk about censorship, and saying, you know, we've had experience obviously with this in the United States in 2016, and that whole after action report process got totally screwed up and politicized, and we're now in a bad place, in my opinion, in the United States on how to think about malign foreign influence. But first of all, to what extent is this focused on, limited to foreign information manipulation and interference? And to what extent might that slop over into or expand over into domestic, within Europe, speakers and speech, which one political party or participant might deem to be disinformation or misinformation, but it's not foreign directed or influenced or inspired or supported or promoted or augmented? Are we talking here for this digital shield, democracy shield, foreign influence or foreign influence plus?
Okay, so when we talk about influence and interference in our elections, and when we speak about the democracy shield, yes, it does address foreign interference in elections, but you can also have autocratic regimes that are adopting approaches such as limiting the space for a free and pluralistic and independent media that restrict the voice of civil society and narrow the space within which they can operate, that seek to undermine and ultimately remove the independence of the justice system and the judiciary within a member state. And these are all fundamental elements of any healthy and functioning democracy. And we are seeking to make sure that all of that is fully protected. And let me address it head on, because freedom of speech is safe in Europe. I would say is safer in Europe than perhaps in any other part of the world, because it is part of our values. It is a right that every EU citizen has. And those that accuse us of censorship will point to our digital rule book and our system of regulation of big tech. I think that's the allegation, is that that is the instrument of use to apply censorship and restrict freedom of speech. The opposite actually is the case. There is nothing in the Digital Services Act that requires a platform. There's no power within the DSA to require any platform that is under the ambit of the DSA to remove legal content from its platform. No power whatsoever. What is the case is that illegal content, yes, should be addressed by the platforms themselves, but more fundamentally, they actually have an obligation under the DSA to be transparent with all of their users about what their own content moderation policies are. So if you put up a political comment which might have a strong edge to it, and it gets taken down by the platform, you have a right to know why it was taken down, what their content moderation policies are. And in fact, when we look at the evidence under the DSA, we see a very significant number of content moderation decisions made by the platforms themselves that have been reversed because they have been challenged by citizens using the very instrument that we are accused of using for censorship. It's used by the citizen to ensure free speech. So that is actually the truth. And I think we need to do a much better job in the European Union of explaining that, of defending the rule book that we have, which actually protects freedom of speech in the European Union.
Let's turn to the audience. One question here, then I'll go here, but sir?
Sure.
Oh, we're going to use the mic. Yeah, for the online folks,
Sure.
we got to go back and forth with the mic.
So I have two passports, the American one and then the EU one. I'm hoping this supports me some extra color by asking a delicate question on individual. But the particular concern that I had was about the AI Act. So why do you think, Commissioner, why was the European Commission reluctant to adopt ISO 42001 as the enforcement view? Is it because ISO charges for standards and that's an issue? Is it because Senelec wanted something to do? Can you tell us a little bit about the AI Act and sort of the enforcement, and why wouldn't we want to harmonize that particular law?
Here, let me do this to make it easier so we don't have to run back and forth with the mic.
Yes, so I should say that the AI Act falls under the competence of my colleague, the Executive Vice President, Henry Cunnin, who manages DG Connect and has overall responsibility for AI policy and the rollout of the AI Act. It is a relatively new piece of legislation, as you know, and we have decided as part of the Digital Omnibus to bring forward a number of targeted specific amendments to the AI Act, including some additional time. And I think that that is appropriate given the consultations that we have had. We did engage with industry and with other stakeholders in relation to that. We remain fully committed to the AI Act and to having a system of balanced regulation of artificial intelligence within the European Union. And that involves consideration of what are the appropriate enforcement mechanisms.
Walking us through very clearly through these latest initiatives and regulations of EU. My name is Michael McGrath. I come from Estonia. I'm here at Stanford as a short-term visiting fellow. I have a question regarding the latest good news from Europe. That is from Budapest, from the latest elections there, the new government. Does Brussels think about how to give a boost the new democratic government of Hungary in their effort to root out corruption and strengthen the democracy, make it more resilient?
Thank you for your question. So we will work with the incoming Hungarian government as they seek to address the various reforms that are necessary and to undo some of the changes that were made in recent years by the outgoing government. The challenges that we've had from a rule of law perspective as a commission with Hungary are well documented. And I sincerely hope that we can turn a new page in our relationship with Hungary on rule of law issues, and that the ordinary citizens of Hungary can enjoy the full benefits of EU membership. Because, as you know, one of the instruments that we have when there are rule of law breaches by a member state is to invoke the conditionality mechanism, which is where certain funds can be denied of a country. And, you know, one of the tragedies of having to do that is that the end beneficiaries lose out. But what other way do we have of trying to hold a country to account? You know, we bring infringement proceedings where necessary, and we have won the infringement cases that we brought against Hungary. There are significant judgments due in the coming months on a number of other cases. And we have had the Article 7 procedure initiated by the European Parliament since 2018 that has been live at council level over that period of time too. But we want to have, you know, a normal, healthy relationship with the Hungarian government on rule of law issues. We will work with them now in a spirit of cooperation. We will support them in every way we can. And I think the important thing that we want to see on their part is just good faith, that they are making best efforts. We know none of it is going to be easy. They will face many challenges as an incoming government, and you can't undo everything overnight. But there were very clear reasons why we had to take the serious steps that we took in terms of the conditionality regulation, the use of the Recovery and Resilience Facility, where we built in super milestones on rule of law related issues, again, which resulted in funds that really should be made available to Hungary by right, not being possible to be made available, and indeed some Hungarian students not being able to benefit from the Erasmus program, which was a real tragedy. And we've learned from all of that too, and we want to move to a system of what we call smart conditionality, where the end beneficiaries can continue to benefit from EU funds, but also where possible that we would do direct management so that we could, if required, bypass the government if they are engaging in rule of law breaches, that we can ensure the funding continues to go to those that deserve it and who need it. But to answer your question, we look forward to working with the incoming government. I think it'll be another few weeks, but before they are formally in office, they have a huge opportunity now to turn the page. And the Hungarian people have clearly chosen a European path, and that is something I think to be welcomed. So let's seize the opportunity now and seize the momentum that has been provided by the democratic choice that the Hungarian people have made.
One or two more questions, yeah. The lady first, yeah.
Thank you so much for all the insights, Commissioner. My name is Natalie. I'm a European lawyer working at Taylor Wessing, European-based law firm who has an office in San Francisco. I have a question regarding the Digital Fairness Act. I think there's also like a very hotly debated topic around the social media ban, or like social media ban for under 16 in connection with the Digital Fairness Act. Can you give us more on that? I know that the EU Parliament had a proposal in November. Ursula von der Leyen talked about it. Will it come with the Digital Fairness Act, or is there a plan to amend the Digital Services Act? Yeah.
As you know, President von der Leyen announced in her State of the Union address last year that an expert panel would be established to examine the very question of potential age restrictions for children on social media. Their work is underway, it's up and running, and we expect that they will report back to the Commission this summer, and we will consider their recommendations and make a decision at that point whether or not to propose an EU-wide law in respect of potential age restrictions. So no such decision has yet been made, and therefore the question of what legislative vehicle to do it doesn't arise at this point. I think there are different views within the European Union on this very question, as I'm sure there are across the United States as well. But this expert panel have been asked to look at the evidence and to come back with their recommendations. But what we are doing in the interim is we are putting in place building blocks that will allow for a better protection of children online, particularly when using social media. So just yesterday, President von der Leyen and EVP Verkunnen confirmed that the technical work is now complete on the EU age verification app. So that's an essential building block of what we're seeking to achieve overall. And then I do think that altogether, aside from the issue of age restrictions, the Digital Fairness Act can play an important role in strengthening protection of minors online for the reasons that I outlined earlier on.
Any questions from the online audience? Okay, here, sir. Yeah.
Hello. Thank you again, Commissioner, for walking us through this. I'm Ida from the Luxembourg Consulate. I do have a few questions, but I'll just ask one. It will be about the digital omnibus, the different pillars, the GDPR, DMA, DSA, the AI Act. Will you make a difference between larger companies and startups when it comes to when they break the law, the rules, when it comes to punishments, or will they even be exemptions for smaller companies whereas the larger companies have to respect more?
So because we are writing law and we have made a proposal in terms of legislative text, and it has to be very clear what the manner of implementation and enforcement is and what the consequences are of the laws not being applied. What we have done in my own area, for example, of GDPR, is because we are adopting a risk-based approach, we have indicated that for smaller organizations, whether it be for-profits or not-for-profits with up to 750 employees, we are making a change or proposing a change to the record-keeping obligations. So that's one example where we are differentiating in respect of the obligations based on the scale of the organization concerned. But when it comes to enforcement and penalties, we have to set out very clearly in law what the potential range of them is for both small, medium and very large enterprises and organizations.
I think it's getting on close to 1 a.m. in Brussels, which means you're thinking it's 1 a.m. I'm going to do one more question way in the back, a light colored shirt. Sorry, we can't accommodate all, but it's been a long day already, so.
Very much. My name is Julian. I'm from Austria, and very much within the Munich startup community, actually. My question is regarding the EU Inc. I would be interested in how your future view is and when we can expect, realistically speaking, when this legal form can be implemented. The first companies will take place as EU Inc. And what the bottlenecks and maybe further advancing the ambition levels that is required from the startup and scale-up community can be somewhat implemented or further introduced. And then secondly, maybe as a student that has high ambitions, what can you recommend me to, kind of in the European Union, make a difference with the ambitions levels that they will reach someday, the European Union?
Okay. Well, when I was in Vienna a few weeks back, I had an excellent roundtable with entrepreneurs and founders on EU Inc. and they gave us their thoughts and perspectives. It was before we finalised the proposal itself. So the European Council has set the objective for us of achieving agreement between the co-legislators by the end of the year. So we will make every effort to do that. I think it's achievable. Even though it sounds like a long time in EU terms, that is a pretty quick process. Then beyond that, if we do achieve that, a political agreement by the end of the year, there's a process of dotting the I's and crossing the T's, and some while afterwards you have the publication in the official EU journal, the coming into force of the regulation itself, and then a period afterwards the coming into application of the regulation itself. So realistically, you are looking at probably a year or so beyond the political agreement being reached before it would actually come into application. But I think we should all move as quickly as we possibly can. The community raised a number of issues with us in the course of the consultation and the outreach that we had. I think we've been able to address the overwhelming majority of them, particularly on the company law side. And they did want us to have an EU-wide court that would address any disputes that would arise for EU Inc. companies. We engaged with the legal service on that question, and it simply wasn't possible within the competence we have afforded to us under the EU treaties to propose that. But we have encouraged and provided for the EU member states to either set up a new national court or to set up a specialised division within their existing court system to deal with EU Inc. Disputes.
Shades of Delaware for American lawyers.
But I would make the point that national courts are also EU courts, and we are, as part of our European judicial training strategy, aiming to significantly ramp up investment in training of judges to make sure that EU law is evenly and consistently applied, and EU Inc. will be EU law, and it should be applied in the exact same way throughout the European Union. The other key ask that they had was having a central register of EU Inc. companies, and we have committed to that. We've provided for that in the legal text. We're going to start with a portal user interface. So when you're setting up an EU Inc. company, you can either do it through that or through the national system currently. But over time, we will work towards a full EU-wide central register or database of EU Inc. companies. Your second question was about how you could influence policy, is it, or become involved? Do you want to clarify? What's it? Yeah.
Just giving or that feeling that a lot of people here want to change or make legislation easier, as we can see here, Y Combinator, different forms that they have there that are attractive to investors. We want to see, and my question is, what can I do so that, I don't know, maybe in my own country, Austria, or on the EU level, like politicians get further the community's efforts?
Yeah, what I would say is that there's a lot of dialogue in Europe, and that's a good thing. Sometimes we take longer than we might like to arrive at a decision or to implement it, but I think in the main we do get it right ultimately. And when I look at the EU Inc. Pathway over the last 18 months or so, there has been extensive dialogue and many roundtables, many opportunities for people who are directly involved, who have experience and knowledge and expertise in the area to make a contribution. And we are generally quite accessible, and there are lots of opportunities for people to have their say. And I think we do all share the same objective. We want Europe to be a much more attractive place to establish a company, but also to build a company to a truly global scale. And we know what needs to be done. EU Inc. is an important part of the jigsaw, not the only piece, as I said earlier, but a necessary one. Without it, we simply won't be able to achieve what we want to.
Michael McGrath, thank you very much.